Hello everyone, welcome back to Learning Legal English through Case Law series. In this video, we'll study Case Law 0.48/2021/AL. Case Law 0.48/2020/AL extenuating circumstance to reduce criminal liability of returning illegal profits. Includes 5 parts. Part 1, Source of the Case Law. Part 2, Overview of the Case Law. Part 3, Content of the Case. Part 4, Assessment of the Court. Part 5, Rules. This case is approved by the Council of Judges of the Supreme People's Court on November 25, 2021 and announced in Decision Number 594/QDCA dated December 31, 2021 of the Chief Justice of the Supreme People's Court. Cassation Decision Number 03/2020/HSGDT dated April 22, 2020 of the Council of Judges of the Supreme People's Court on the case of gambling and gambling organization against defendant Ho Tsong Nhat Q, Ho Viet H. Nguyen Mong V. Part 2, Overview of the Case Law. Case Law Situation. The accused or defendants returned the illegal profits from the crime. Legal solution. In this case, the court must determine that the defendant is entitled to an extenuating circumstance of criminal liability under Clause 2, Article 46 of the Penal Code 1999, corresponding to Clause 2, Article 51 of the Penal Code 2015 as amended and supplemented in 2017. Key words of the case law. Returning illegal profits. Extenuating circumstances of criminal liability. Gamble. Gambling organization. Part 3, Content of the Case. On September 20, 2016, the Investigative Police Department of the Police Department of T Province discovered and arrested a number of subjects who had organized illegal gambling through the internet on a large scale and with many participants. The method of organizing gambling behavior of this group is to receive betting accounts on the IBT site, divide them into many subordinate accounts, and then authorize the subordinates to organize gambling or directly delivered to unauthorized gamblers via the internet. This is an unauthorized football betting account on a foreign website, using an English interface containing a virtual dollar amount, hereinafter referred to as dollar, and the dealer and the account recipient agree on exchange rate of each dollar to Vietnam dong. In order to organize illegal online gambling, the subjects in this case installed computers with internet connection, used laptops and mobile phones with Wi-Fi connection as tools and means of organizing the gambling. The payment of winnings and losses between the teams is conventionally in Vietnamese currency, delivered directly or sent through other familiar subjects. The dealer pays the player a commission through the above account in the gross com section. In order to make profit, the gambling organizing subjects in this case have increased the exchange rate of each dollar to a higher level than they have received, which is actually a form of capital partnership, contributing more money with the dealer to gamble with players. At the same time, to encourage players, gambling organization subjects also increased the commission paid for each account by 2 to 3 times. In particular, the behaviors of Ho Tsong Nhat Q, Ho Viet H, and Nguyen Mong V are as follows. In February 2016, Q claimed to have received from subject P, name and address unknown, a football betting account TKV2 on IBD betting website, with a bet amount of $3 million. P and Q agreed on the convention that $1 is worth 5,000 VND, the commission P shall pay Q through the gross com section. After receiving the TVK2 account, Q created 19 subordinate accounts. These accounts Q installed $5,000 per account and reissued them to gamblers or gambling organizations, in which Q granted 03 accounts to Nguyen Mong V, 03 accounts to Ho Viet H and some other subjects. Q kept 02 accounts and then created many subordinate accounts and created many separate pages to grant to gamblers when needed. During the investigation, the investigating agency obtained detailed documents of 07 accounts, TVK204, TVK20B, TVK20K, TVK20N, TVK20P, TVK219 and TVK20S. Q granted LUhet H the following accounts: TVK20B, TVK204, TVK20K with the convention that TVK204 is 10,000 VND/$, TVK20B and TVK20K is 7,000 VND/$. From June to September 2016, plus on TVK204 account, there is a bet amount of $116,877, plus on TVK20B account, there is a bet book of $261,819, plus on TVK20K account, there is a bet amount of $131,060. Q granted Nguyen via accounts TVK20N, TVK20P, TVK20S with the convention that TVK20N and TVK20P accounts are 7,000 VND/$, TVK20S account is 6,500 VND/$. From early June to September 2016, plus on TVK20N account, there is a bet amount of $28,583, plus on TVK20P account, there is a bet amount of $152,542, plus on TVK20S account, there is a bet amount of $247,592. Q grants a subject named Q1, living in the United States, a TVK219 account with the convention of 6,000 VND/$. From June to September 2016, this account had a stake of $96,404. In total, Q must be criminally responsible for the crime of organizing gambling through the above 07 accounts, which is $116,877 plus $261,819 plus $131,060 plus $28,583 plus $152,542 plus $247,592 plus $96,404 5,000 VND/$ equals $5,174,385,000 VND. The commission Q received through gross com is $8,759,400 VND. The commission Q paid to H is $22,713,030 VND. The commission Q paid to V is $10,533,887 VND. The commission Q paid to Q1 is $2,656,080 VND. The total commission Q paid to subordinates and players is $35,902,997 VND. Based on detailed documents, summary statements, and the defendant's confessions, Q has increased the conversion of each point to a higher level than received, specifically as follows: the part assigned to H, including the number of points played and the loss to be paid, plus account TVK204, $116,877 plus $43,451.05 x 10,000 VND, 5,000 VND, equals $801,640,250 VND, plus TVK20B account, $261,819 plus $98,676.27 x 7,000 VND, 5,000 VND, equals $720,990,540 VND, plus TVK20K account, $131,060 plus $41,797.44 x 7,000 VND, 5,000 VND, equals $345,714.880 VND. The part assigned to V, plus TVK20N account, $28,583 plus $6,617.7 x 7,000 VND, 5,000 VND, equals $70,401,400 VND, plus TVK20P account, $152,542 plus $61,009.59 x 7,000 VND, 5,000 VND, equals $427,103,180 VND, plus TVK20S account, $247,592 plus $99,584.13 x 6,500 VND, 5,000 VND, equals $520,764,195 VND. The part assigned to Q1, TVK219 account, $96,404 plus $42,802.9 x 6,000 VND, 5,000 VND, equals $139,206,900 VND. The total amount that Q used to gamble on TVK2 account is $3,025,821,385 VND, in which There are 74 betting turn with the amount of money received in lost bets must be paid from 5 million VND/turn or more with a total gambling amount of 692,170,780 VND, remaining 13,480 turns with the amount of bets received and lost in each turn of less than 5 million VND/turn with a total amount of 2,333,650,605 VND, so they will not be criminally penalized through gambling. Q1 on these 07 accounts 884. 599,190 VND, Q lost 825,636,385 VND, so Q made a profit of 58,962,805 VND. Ho Viet H received from Ho Song Not Q accounts TBK 204, $1 equals 10,000 VND, TBK 20B, $1 equals 7,000 VND, TBK 20K, $1 equals 7,000 VND, then H granted account TBK 20B to Chao on T and convened that $1 equals 12,000 VND for T to divide into many separate pages for players. H pays T commission at the rate of gross calm x4. Account TBK 204, H creates 05 lower level accounts and from these 05 accounts creates 13 separate pages for direct gambling. Account TBK 20K, H also creates 03 subordinate accounts and from these 03 accounts create 12 separate pages for direct gambling. Based on detailed documents, summary statements and confessions of the defendants, it was determined that H's gambling organization behavior is as follows. After receiving account TBK 20B with the rate of 7,000 VND/$, H granted the account to Chao on T. From March 1, 2016 to September 20, 2016, on TBK 20B account. The total bet amount is $261,819 x 7,000 VND equals 1,832,733,000 VND. The commission H received from Q is 11,279,310 VND. The commission H has to pay to T is 25,781. 280 VND, so H does not profit from the gambling organization. Gambling behavior through Chao on T, because H gave T the account TBK 20B at the rate of 12,000 VND/$, H contributed capital with the gambling dealer to gamble with his subordinate at 5,000 VND/$. Thus, the amount H used to gamble on this account was $261,819 plus $98,676.27. He's lost money, x 5,000 VND equals 1,802,476,350 VND, in which there are 61 turns of bets profit and losses from 5 million VND/turn or more with a total gambling amount of 643,134,000 VND. The remaining 7,381 turns of bets receive and losses less than 5 million VND/turn with a total amount of 1,159,342,350 VND. H wins on this account 507,499,700 VND, H lost 493,381,350 VND, so H's profit is 14,118,350 VND. Acts of gambling with the dealer. After receiving TBK 204 and TBK 20K accounts, H created many separate pages and then directly gambled with the dealer. From March 1, 2016 to September 20, 2016, on these two accounts, the total bet amount was $247,937. That of TBK 204 was $116,877. TBK 20K was $131,060. The money H won on these two accounts is $85,248.49, TBK 204 is $43,451.05, TBK 20K is $41,797.44. Thus, H has gambled on TBK 204 account $116,877 plus 43. $451.05, x VND 10,000 is equal to 1,603,280,500 VND and gambled on TBK 20K account, $131,060 plus $41,797.44, x 7,000 VND equals 1,210,2080 VND. On these two accounts, there are 115 turns of bet with betting amount and winning amount of 5 million VND/turn or more with a total gambling amount of 1,282,290,840 VND, remaining 3,187 plays with bets and winnings under 5 million VND/turn with a total amount of 1,530,991,740 VND. The money H wins when gambling on these two accounts is 727,092. 580 VND. The money H lost is 772,741,000 VND, so H did not profit from gambling. The total amount H must be criminally responsible for gambling on these three accounts is 643,134,000 VND plus 1,282,290,840 VND equals 1,925,424,840 VND. The remaining 10,568 plays with the amount of 2,690,334,090 VND because the bet amount is less than 5 million VND/turn, so they will not be penalized. The commission H received for gambling is 11,433,720 VND. Nguyen Mong V received from Hotsong Not Q03 accounts, TVK20N, $1 equals VND 7,000, TVK20P, $1 equals VND 7,000, and TVK20S, $1 equals VND 6,500, then V reissued the TVK20P account to Nguyen Van V. V pays a commission to be of 1% of the total bet amount on the account. The remaining accounts V creates subordinate accounts, then continues to create 10 separate pages to directly gamble with the dealer. V received from Q account TVK20P with the convention of $1 equals 7,000 VND. From September 1, 2016 to September 20, 2016, on TVK20P account managed by V, there was a total bet amount of $152,542. Thus, V must be held criminally responsible for the crime of organizing gambling of $152,542 x 7,000 VND equals 1,067,794,000 VND. The commission V received was 5,947,200 VND, the commission V paid to B was 12,203,360 VND, so V did not profit from this behavior. Because V granted account TVK20P to B with the convention of $1 equals 8,000 VND, V has contributed capital with the gambling dealer to gamble with his subordinates at 1,000 VND/$1. The amount of money V gambled on this account is 213,551,590 VND, but there are no bets with bet amount receive and loss from 5 million VND/turn. The total amount of money V won in gambling was 1,374,920 VND. After receiving accounts TVK20N, TVK20S, V created 10 separate pages and then directly gamble with their higher levels. From August 1, 2016 to September 20, 2016, on TVK20N account, there was a total bet of $28,583, V won $6,617.7, V lost $9,617, a total gambling amount of V on the account is $28,583 plus $6,617.7, x 7,000 VND equals 246,404,900 VND. On TVK20S account, there is a total bet amount of $247,592, V won $99,584.13, V lost $112,753. The total amount V gambled on this account is $247,592 plus $99,584.13, x 6,500 VND equals 2,256,644,845 VND. Thus, the total amount of money V gambled in the above two accounts is 246,404,900 VND plus 2,256,644,845 VND equals 2,503,049,845 VND. In which, there are 173 times the bet amount and the winning amount is from 5 million VND/turn or more with a total gambling money of 1,938,520,070 VND, Remaining 286 turns the bet amount and winnings are under 5 million VND/time with a total amount of 564,529,675 VND. The amount V won in gambling on these two accounts was 693,620,745 VND, V lost 800,213,500 VND. So V did not make a profit. The commission V received from Q of these two accounts is 4,586,688 VND. The total amount of money V must be criminally responsible for when gambling on these 03 accounts is 1,938,520,070 VND. Remaining 1,246 plays with the amount of 778,801,265 VND because the bet amount and winnings are under 5 million VND/turn, so they are not prosecuted for criminal liability. At the first instance criminal judgment number 04/2018/HSST dated January 16, 2018, the People's Court of TIธ์Province decided. Applying Clause 1 of Article 249, points B and P, Clause 1, Article 46 of the 1999 Penal Code, sentence Ho Song Not for 1 year and 3 months in prison for the crime of organizing gambling. Applying point B, Clause 2, Article 248, points B, O, P, Clause 1, Article 46, Article 47 of the 1999 Penal Code, sentenced Ho Song Not Q to 10 months in prison for the crime of gambling. Applying Clause 1 of Article 249, points B and P, Clause 1 and Clause 2 Article 46, Article 47 of the 1999 Penal Code, sentenced Ho Viet H to 9 months in prison for the crime of organizing gambling. Applying point B, Clause 2, Article 248, point B, O, P, Clause 1, Clause 2, Article 46, Article 47 of the 1999 Penal Code, sentenced Ho Viet H to 6 months in prison for the crime of gambling. Applying Clause 1 of Article 249 applies, points B and P, Clause 1 and Clause 2 Article 46, Article 47 of the 1999 Penal Code, sentenced Tang Wen Mong to 6 months in prison for the crime of organizing gambling. Applying point B, Clause 2, Article 248, points B, O, P, Clause 1, Clause 2 Article 46, Article 47 of the 1999 Penal Code, sentenced Tang Wen Mong to 6 months in prison for the crime of gambling. Applying Article 50 of the Penal Code, synthesizing penalties, forcing the above defendants to serve the total penalty of both crimes, specifically, for Q, it is 2 years and 1 month in prison, that of H is 1 year and 3 months in prison and V is 1 year in prison. On January 30, 2018, Ho Song Not Q, Ho Viet H and Nguyen Mong V appealed for a suspended sentence. In the Appellate Criminal Judgment Number 158/2018/HSBT dated June 27, 2018, the High People's Court in Da Nang decided to apply Clause 1, Article 249, point B, Clause 2, Article 248, points B, O, P, Clause 1, Clause 2 Article 46, Article 47, Article 50 of the 1999 Penal Code, sentence Ho Song Not Q 9 months in prison for the crime of organizing gambling and 6 months in prison for the crime of gambling. Combining the penalties, forcing Q to serve the total penalty of both crimes of 15 months in prison. Ho Viet H was sentenced to 5 months in prison for the crime of organizing gambling and 4 months in prison for the crime of gambling. Augmenting the penalties, forcing H to serve the total penalty of both crimes of 9 months in prison. Nguyen Mong V was sentenced to 4 months and 19 days in prison for the crime of organizing gambling and 4 months in prison for the crime of gambling. Augmenting the penalties, forcing V to serve the total penalty of both crimes of 8 months and 19 days in prison. In decision number 03/2019/KNHS dated June 19, 2019, the Chief Justice of the Supreme People's Court protested the Appellate Criminal Judgment number 158/2018/HSBT dated June 27, 2018 of the High People's Court in Da Nang, proposed the Judicial Council of the Supreme People's Court to conduct cassation trial and abrogate the above-mentioned appellate criminal judgment and the first instance criminal judgment number 04/2018/HSST dated January 16, 2018 of TIธ์Province People's Court. Regarding the main and augmenting punishments for Ho Song Not Q, Ho Viet H, Nguyen Mong V, hand over the case files to the People's Court of TIธ์Province for retrial in accordance with law. At the cassation hearing, the representative of the Supreme People's Procuracy agreed with the protest decision of the Chief Justice of the Supreme People's Court. Part 4. Assessment of the Court. Hotsong Not Q received a football betting account belonging to IBT website to split it into 19 accounts. Q kept 02 accounts, the remaining accounts Q assigned to Ho Viet H, Ng Nguyen Mong V and some other subjects to organize gambling in gambling. After Ho Viet H and Nguyen Mong V received 03 accounts each, H and V each kept 02 accounts and assigned 01 account to Chow T and Nguyen Van B to organize gambling in gambling. In this case, the total amount that Q was accused of organizing gambling was 5,174,385,000 VND, H was 1,832,733,000 VND and V was 1,067,794,000 VND. The defendant's act of organizing gambling was in large scale qui molan specified in Clause 1, Article 249 of the Penal Code 1999, which carries a penalty bracket of between 1 year and 5 years. From the retained accounts, H and V created many separate pages and then directly gambled with the dealer. At the same time, Q, H and V also increased the exchange rate of each dollar to higher than the amount received when handing the account to someone else, so Q, H and V had gambling behavior with the player. Out of the total number of gambles that the investigative agency has collected, Q must be criminally responsible for 74 plays with the amount of bets and losses payable from 5,000,000 VND/turn or more with a total amount of 692,170,780 VND. H must be criminally responsible for 176 plays with the amount of money received and lost from 5 million VND/turn or more with a total amount of 1,925,424,840 VND. V must be held criminally responsible for 173 plays with the amount of receiving bets and losing bets having to pay from 5 million VND/turn or more with a total amount of 1,938,520,070 VND. Defendants Q, H, and V are charged with the crime of gambling according to the provisions of Clause 2. Article 248 of the Penal Code, with the penalty bracket of imprisonment between 2 years and 7 years, which is a serious crime. When adjudicating the case, the first instance court applied point B, Clause 1, Article 46 of the Penal Code to the above defendants was incorrect, because the return of illegal profits is not an extenuating of penal liability according to point B, Clause 1, Article 46 of the Penal Code, but extenuating circumstances under Clause 2, Article 46 of the Penal Code. On the other hand, the first instance court applied the circumstance of the offender confesses as an extenuating circumstance for the criminal liability of the defendants according to point O. Clause 1, Article 46 of the Penal Code is illegal because Q and V were arrested under an emergency arrest order for illegal internet gambling. After being arrested, Q confessed to the crime. On October 4, 2016, H was prosecuted for the crimes of gambling, organizing gambling, and was arrested under the arrest warrant for the accused to be detained. During the investigation of the case, the defendant's declaration of gambling behaviors was a fact of sincere declaration, not a case of confession. In addition, the defendants made many rounds of gambling with an amount of VND 5 million or more, but the first instance court did not apply the aggravating circumstances of penal liability specified at point G, multiple offending, Clause 1, Article 48 of the Penal Code with Q, H and V is a failure. Therefore, the first instance court's application of Article 47 of the Penal Code to these defendants was not grounded, sentencing Q 1 year and 3 months in prison, H 9 months in prison, V 6 months in prison for the crime of organizing gambling and sentencing Q 10 months in prison, H 6 months in prison, V 6 months in prison for the crime of gambling, below the lowest level of the penalty bracket, is too mild, cannot ensure the strictness of the law. The Court of Appeal did not find the first instance court's mistake, overemphasizing some extenuating circumstances that were considered and applied by the first instance court, such as the defendant's return of the profit gained illegally, being the main labor in the family, whose children are still young. At the appellate level, there were more circumstances such as the defendants having paid enough additional fines. Defendant Q paid enough the amount of illicit profits Q's father has Contributed efforts in the locality. As new extenuating circumstances, which were not significant, to reduce the punishment for the defendants, sentenced Q to 9 months in prison, H to 5 months and V to 4 months and 19 days of prison, for the crime of organizing gambling, and sentenced Q 6 months in prison, H 4 months in prison. Prison, V 4 months in prison for the crime of gambling were a serious mistake in the application of the law, not commensurate with the nature and the seriousness of the crime and the role of the defendants in the case. Not meeting the requirement to fight and prevent this type of crime. Part 5, Rules. Pursuant to Article 382, Article 388 and Article 391 Criminal Procedure Code 2015. Abrogate the Appellate Criminal Judgment Number 158/2018/HSPT dated June 27, 2018, of the High People's Court in Da Nang, and the First Instance Criminal Judgment No April 2018/HSST dated January 16, 2018, of the People's Court of TIธ์Province on the main and augmentation of penalties for Ho Tsong Nut Q. Ho Viet HN Nguyen Mong V. Transfer the case file to the People's Court of TIธ์Province to conduct the retrial in accordance with the law. Accept the protest decision No March 2019/KNHS dated June 19, 2019, of the Chief Justice of the Supreme People's Court. Content of the case law. When adjudicating the case, the First Instance Court applied point B, Clause 1, Article 46 of the Penal Code to the above defendants was incorrect, because the return of illegal profits is not an extenuating of penal liability according to point B, Clause 1, Article 46 of the Penal Code, but extenuating circumstances under Clause 2, Article 46 of the Penal Code.